A traffic stop, a rental car, a 24-year-old man shot dead. 12 minutes later, his mother's life would change forever. 9 years later, the Supreme Court just changed yours in a shocking 9-0 ruling. The court has obliterated a legal doctrine that's protected police for decades, the so-called moment of threat standard. And this wasn't a split court. This was every single justice from Barrett to Sotomayor standing together. What happened? What does it matter? And most importantly, how does it affect you as a citizen, as a gun owner, or as someone who might one day be stopped by police? Because the rules just changed, and if you ever find yourself in that moment, hands on the wheel, red and blue lights behind you, this decision could make all the difference. Let's break it down. And no, it's not as simple as pro-cop or anti-cop. This is about the Constitution, deadly force in a brand new legal precedent that reshaped the rights of every American. It happened on a quiet afternoon in Harris County, Texas, April 28, 2016. Officer Roberto Felix spots a car linked to some unpaid tolls. Nothing major, just a routine traffic stop. Inside that car, a 24-year-old named Ashton Barnes. He pulls over, no problem, no drama, no chase. Just a young guy sitting on the shoulder of the highway in a rental car. Felix walks up, asks for license and insurance. Ashton says he doesn't have his license on him, and yeah, the car's not his, it's his girlfriend's rental. The toll violations, not even his mess. In Texas, not having your license on you is basically a slap on the wrist. A $10 ticket if you prove later that you actually have one. No reason this should have gone any further. But then, things shift. Felix says he smells marijuana. He asked if Ashton has anything in the car that he should know about. Ashton stays calm, turns off the engine, drops the keys by the gear shift, says maybe the insurance is in the trunk. That moment right there was the last bit of calm. From the dashboard, you see Ashton open the trunk. Then the blinkers go off. Car shut down. Then back on. The car starts moving. Felix draws his weapon, yells, "Don't move," then jumps into the moving car. Seconds later, gunfire. 2 shots. 12 minutes later, Ashton is dead in the driver's seat. Now, here's the kicker. Felix claims self-defense. Said he feared for his life. But let's pause and be real. He jumped into a moving vehicle. He wasn't dragged. He wasn't ambushed. He chose to step into danger, then fired 2 rounds into the car with no visibility and hit the man who hadn't laid a hand on him. That's what the whole case comes down to. Now, whether Felix was afraid in that final second, but whether that final second ever needed to happen. Now, here's where things get murky and maddening. After the shooting, 2 things kicked off: a criminal investigation and a civil lawsuit. First, the criminal side. Houston PD Homicide Unit reviewed the footage. Internal Affairs followed up. No charges, no reprimand, no suspension. To them, Officer Felix acted within policy. But Ashton's family wasn't satisfied with policy. They wanted accountability. They believed the law had been twisted. That this wasn't a moment of self-defense, but a preventable killing dressed up in legal armor. So they filed a civil lawsuit under Section 1983, the federal statute that allowed citizens to sue government officials for constitutional violations. In this case, excessive force under the 4th Amendment. At the district court level, the judge threw it out. The reasoning? Felix feared for his life at the moment he pulled the trigger. That made it reasonable, even if everything leading up to that moment was reckless. To be blunt, the court treated it like a still frame, zoomed in on 1 second, froze it, and declared it justified. But what about the buildup? What about the officer jumping into danger? What about everything that could have stopped this from happening? Didn't matter. When Ashton's family appealed, the 5th Circuit Court of Appeals upheld the lower court's decision. And this is where the infamous legal test comes in, the moment of threat standard. Here's how it works. Courts evaluate only the instant deadly force was used. So even if the officer escalated, acted recklessly, or ignored safer alternatives, none of it mattered, so long as they felt threatened in that final second. Think about that. A cop could break protocol, leap onto a moving car, ignore backup, and still claim self-defense if they say, "I thought I was going to die." That's not just a loophole, that's a shield. And it's one that's protected officers in case after case. Lawyers, legal scholars, and civil rights advocates have been warning about this for years. They argue that the moment of threat doctrine erased context, rewarded recklessness, and put the Constitution on pause because that moment things turned deadly. So Ashton's parents made the ultimate move. They took it to the Supreme Court of the United States. And here's the twist no one saw coming. In a country this divided, on a bench this ideological, all 9 justices agreed. From Justice Barrett to Justice Sotomayor, the court ruled unanimously that the old test was wrong. They didn't just reverse the Fifth Circuit, they redefined how courts must assess use of force cases. The court said that it's not enough to look at the final second. Judges must now consider the totality of the encounter. Every choice the officer made, every alternative they ignored, every action that may have created the danger. If the officer escalated the situation unnecessarily, if they created the lethal scenario, then they could be held liable, period. This wasn't just a ruling, this was a reset. The court even referenced prior precedents like Tennessee versus Garner and Graham versus Connor, 2 cornerstone cases that laid the groundwork for modern use of force law. But this decision sharpened the test. It closed the blind spot. Now, by doing that, it didn't just help Ashton Barnes' family, it changed how every future police shooting will be judged, not just in Houston, but nationwide. Here's what stunned everyone. It wasn't a 5-4 or even a 6-3 decision. It was 9-0, unanimous. And a court that's been split down the middle on gun rights, abortion, executive power. Somehow, this case brought every justice to the same side. Why? Because deep down, this wasn't about politics. It wasn't about left or right. It was about basic accountability. Whether you wear the badge or face the badge, the Constitution is supposed to protect everyone the same. And the moment of threat standard, that created 2 classes of justice, one for citizens, one for the state. Even Justice Kavanaugh, often labeled as pro-law enforcement, agreed that courts were doing it wrong. He said focusing on the split second freezes time, ignoring everything that led up to it. Justice Sotomayor, on the other hand, has long warned that unchecked police powers erode civil rights. But this time, she didn't have to write a scathing dissent because they all saw it from different angles but with the same result. This wasn't just about one officer or one shooting. It was about a legal doctrine that had tipped the scales too far, one that excused avoidable deaths under the banner of "I was scared." And maybe, just maybe, the court realized that keeping the standard would only deepen public mistrust, not just in police, but in the justice system itself. So they sent a message. You can't cause chaos and then claim the law protects you from a fallout, not if you're the one who lit the fuse. The ruling doesn't make every shooting illegal, but it means no more shortcuts, no more one-frame snapshots in court. From now on, the story has to be told from start to finish, and every chapter counts. So what does this ruling actually change? A lot more than most people realize. Let's start with you. If you carry a firearm, if you've ever been pulled over, and if you've ever had an officer approach your vehicle, your home, or your property, this decision reshapes how that intersection is judged after the fact. Because before the ruling, courts could zoom in on a single moment. They'd ask, was the officer afraid? And if the answer was yes, even if that fear came from their own reckless decision, they walked. But now the question changes. Should the officer have been in that situation at all? That's a big shift because it gives context legal weight. And context, as a gun owner knows, can be the difference between lawful carry and criminal prosecution. Let's put this in practical terms. Say you're legally armed. An officer approaches. Things get tense. You are compliant, but he's agitated. And something happens. Maybe you flinch, maybe he misread your move, and he fires. Under the old rule, the court would freeze frame that 1 second. Under the new rule, they're now required to ask, did the officer escalate? Was this person cooperating before it turned deadly? Could this have been avoided? For lawful gun carries, and especially for minorities who carry, that really matters, because now your behavior before the trigger was pulled can't be erased in court, and neither can the officers. But this ruling isn't just a win for civil rights. It also sends shockwaves through law enforcement training, liability insurance, and even policy manuals. Police departments across the country will now have to reevaluate how they teach officers to approach cars, enter homes, conduct stops, and handle perceived threats. Because if an officer makes a bad call early, jumps on a moving car, breaks protocol, escalates tension, and that ends in gunfire, then they're on the hook. That means more lawsuits, more scrutiny, more internal reviews. Some officers will see this as handcuffs, others as a long overdue call for smarter tactics. What about prosecutors? This ruling gives them new tools. Before, if a cop said, "I fear for my life," the case often died right there. Now they can argue the entire encounter was flawed, not just the final frame. The defense attorneys, they now have leverage in court to bring full context into play, something denied in case after case until now. Now, let's step back even further, because this ruling doesn't just affect traffic stops or officer-involved shootings. It touches the very core of the Fourth Amendment, the right to be secure in your person, your house, your papers, and your effects against reasonable searches and seizure. That's not just a dusty line from 1789. It's your shield when the sirens light up. It's your guardrail when the state gets too close. And now, that shield just got stronger. The court didn't rewrite the Constitution. They recentered it. They reminded the lower courts that force can't be judged in a vacuum, because if government agents can provoke a threat and then justify killing you because they feel threatened, that's not justice, that's immunity with a badge. But let's be clear, this ruling isn't a green light to resist policy or ignore commands. It's a reminder that both sides of the badge carry weight. From now on, the courts have to carry that weight too. So what does the future look like? For civilians, this ruling offers hope, protection, maybe a path to accountability that's been missing for too long. For officers, it raises the stakes. No more shortcuts. Every move counts. And for the Constitution, this ruling is one of the strongest reaffirmations of Fourth Amendment protections in a generation. It says you can't jump into danger and claim the law protected you from your own choices. Not anymore. So what do you think? Did the Supreme Court finally strike the right balance, or did they just make police work more dangerous and complicated? Drop your thoughts in the comments. We read every single one. And if you care about your rights, or just want to stay ahead of every single shift affecting gun owners in America, hit that subscribe button and turn on notifications, because we don't do fluff, we do facts, case law, and straight talk without the politics. Until next time, stay alert, stay armed, and carry with your eyes open.